And for some legal analysis, we're now joined via video link by J.P. Venter. He is a senior associate at the Ulrich Roux and Associates law firm. Mr. Venter, very good afternoon to you. Thanks for joining us. Welcome.
Good afternoon. Thank you for having me.
Well, first of all, Mr. Venter, some legal pundits actually saw this coming. But broadly speaking, can you perhaps unpack the significance of an urgent application being struck from the roll as opposed to being dismissed? I mean, what does that tell us about the merits and the urgency of Bester and Magudumana's case?
Look, it happens quite often that urgent applications get struck off the roll for the lack of urgency, as the judge found here that the urgency in this matter was self-created. Since the doctor knew about or saw this trailer already on the 20th of August and basically sat and did nothing, and then on the eve of the airing of the specific documentary, she wants to run to court and bring an urgent application. The court found the court will in general not grant a urgent application if it's self-created urgency at the end of the day. This is quite, like I say, you see it quite often with urgent applications that it's struck for the lack of urgency. Specifically, if you struck it for the lack of urgency, it does not go into the merits of the matter. It just shows that there was no urgency and that you could have brought it maybe on the normal roll in the normal course.
So which then means that the merits issue is still hanging above this case. But then how do the applicant's rights to dignity, privacy and a fair trial weigh against Netflix's right to freedom of expression and the public's right to know? I mean, did the court's decision really strengthen media freedom precedent in South Africa?
Yes, indeed it does. My previous answer was just relating specifically to why it was struck from the roll. This court did go a little bit further in as well, and basically the court dismissed this application on all fronts. There are certain legal requirements that the party has to comply with for this type of urgent applications, except for the fact of urgency. They need to show that they've got a prima facie right that is going to be infringed upon. The court here found as well that there is no right that's going to be infringed specifically. The fair trial right is not going to be infringed. Remember, our courts see it on the daily where people protest outside court, where it's in the news all the time, certain cases. I'm just talking in general now.
Yeah.
Certain cases are on the news. People see it every day. The court had found that judges are not to be swayed by these, and in general are not swayed by the media and public opinion. That is part of their daily duties. The court has also found that witnesses that might have seen this specific documentaries and testify will be subjected to cross-examination, and therefore the rights of a fair trial is still protected during by our normal court procedures that is in place, and the impartiality of our judges. The other aspect that is also quite important is that the courts have found that, remember, on this type of application, there must also be a real apprehension of irreparable harm that's going to be suffered, and that they need this application to stop this harm from occurring. Courts found that there is no such in this specific case, and that they do have other remedies that they can follow afterwards for defamation, or if they felt that there was any injury to any other privacy rights. That is applications that they can bring afterward and claim damages.
Right.
But just to get to the media aspect for you as well, I would like to quote to you just the specific case, if you would grant me the opportunity, that the court has also relied on in this matter, that is the specific case or the locus classicus for this matter, and it's a matter of Medi Television that was decided by our Supreme Court of Appeal in 2007. And I'm going to quote directly from the case, which says prior restraint is a drastic inference and will be ordered only if there is substantial risk of grave injustice that can't be avoided by less restrictive means. In short, show concrete, imminent prejudice to the administration of justice. Mere speculation is not enough. And I believe this is what the court has found here, is that the application is only speculating that there might be infringement on their constitutional rights. There's not concrete proof given of severe infringement of the rights of both applicants in this matter.
Well, I'm actually glad that you touched on the possible, the possible infringement of rights, but Bester and Magudumana argued that this documentary could possibly prejudice their ongoing criminal trial. So how does the court then typically evaluate such claims, and why might the judge have been satisfied that airing this series would not compromise justice?
I think if I just touch back on what my previous answer as well, the judge felt as judges in general gets exposed in not only this matter, in all matters, to the media, to broadcasts in the news, to the newspapers, to digital platforms that is reporting on cases and form opinion. And they see people's opinions on cases all the time. And part of their duties as judges is to be impartial. And we do have a judicial system where our judges, fortunately, do have impartiality most of the time. And the judge felt this is part of their normal duties. To speculate now that a judge would be influenced and not be impartial is premature at this stage. And there is also other legal remedies for if during the trial it becomes apparent that the judge is impartial. There's also legal remedies to remedy that situation at that stage.
All right, Mr. Fenter, great chatting to you. Thank you so much for your analysis.
I think that is what the judge relied on in this judgment.